What goes on at a detention hearing in federal court? My name is Ted Hassey. I'm an attorney at Worth Law Office, handle federal criminal matters here, work out of our Tulsa office, handle all federal criminal matters in Northern District of Oklahoma and Eastern District of Oklahoma. Wanted to talk briefly here about detention hearings. It's kind of the first important step in the whole process. One of the first important decisions that's going to be made if you or your loved one is facing a federal criminal charge. There's going to be a determination at some point early on whether or not they're going to be held before trial. Now, in the state system, here, frequently you have to post a bond. It doesn't work exactly that way in federal court. You're not going to have to go to a bail bondsman and post up money. The idea is that they don't want people who should be eligible to be released pretrial to be held back because they can't put up a bunch of money. So what will happen is after your initial appearance and arraignment, which I've talked about in another video, essentially the defendant will meet with pretrial services, which are, at least in the Northern District, they're generally folks who are connected to U.S. probation and parole. They interview the defendant to gather information that's relevant to, possibly, any detention or detention hearing. Detention hearings can, often be scheduled, very quickly. Often, within sometimes the day of the arraignment, we can have that detention hearing. Other times the next day. Other times a little later in the week. But we can usually get the detention hearing going very quickly. Detention hearings are held in front of U.S. Magistrate Judge, which is not the primary judge that's responsible for each defendant's case. They're, sort of hired on to handle some of the low-level, more routine procedural matters. In the Northern District, though, all the magistrates are really excellent, pay close attention, read motions and are great at what they do, try to approach things fairly. The detention hearing focuses, so let me take a step back. First thing is, the U.S. Attorney's Office, the federal prosecutors will have to decide whether or not they're seeking detention. If they are seeking detention, then there'll be a detention hearing set. At the detention hearing, what, handled before a magistrate judge, which usually looked at are kind of two primary factors. One is the likelihood that if released on pretrial release, whether the defendant will show up and go through the rest of the process, so whether they'll skip town, and then the other is danger to the community. There's a number of factors within each of those that the magistrate judge will examine. It's important that you have good representation for you at that step. Too often I'm hearing about attorneys, sometimes attorneys who are assigned and not retained outside, too often waiving the detention hearing, not even getting the shot in front of the judge. So saying, no, we're not going to have the detention hearing. Rarely does it make sense to not at least get in front of a judge and argue for pretrial release. Some cases are tougher than others. Sometimes there's a presumption in certain cases under certain charges for pretrial detention, which shifts the burden, makes it so that the defense has to sort of make an initial showing, but still, that can be overcome. And even in those cases where there's, so-called shifting of the presumption, oftentimes people can get out pretrial. Every case is different, but usually you're going to end up with a much better result with retained outside counsel. If you have questions for us, we'd be glad for you to give us a call about your case or a loved one's case. Again, my name is Ted Hassey at Worth Law Office. Our number is 918-932-2800.